These are very, very important issues. Most of the people in this room know where they stand on those issues, but there are a lot of people who stand on a different side, one of the most distinguished and eloquent of which is Randy. And so Randy is going to talk about the constitutionality of the health care law, but this broader jurisprudential issue is in the background somewhere.
Thanks. It's a great pleasure to be here. I really enjoy when I'm at the American Constitution Society. I'm a big fan of yours, so it's great to be on a balanced program. I'm here to talk about the constitutionality of the Health Insurance Reform Act. There's not all that much I agree with the Vice President about, but one thing I do agree about is that this bill is a really big deal. But it's not just a big deal in terms of policy, and you've heard some arguments or some analysis of why it's a big deal in terms of policy, but it's potentially a very, very big deal with respect to constitutional matters. And in particular, I think that what the Supreme Court is going to have to say in order to uphold the bill, and in particular the individual mandate, which is what I'm going to focus my attention on, what they're going to have to say to uphold that mandate promises to fundamentally change the relationship of the individual citizen to the federal government in particular, and possibly to the state in general. And that's something that some of you, I think, may welcome on ideological grounds, and that's fine. I understand that. But there are others of you who, once you realize what's at stake here, may actually have some concern about a principle being established in this case, for this policy goal that you may agree with, that could be carried over into other policy areas with which you disagree. And you should at least be aware or go into this witness this litigation with your eyes open. I'm going to try to explain to you why I think you should be concerned. Let me start off by saying something that I've been saying since last December, and that is that the individual mandate, which requires that every person in the United States buy health insurance from a private company, with some exceptions, that the individual mandate is an unprecedented act of federal power. Now, unprecedented has two senses that are related in this context. One is the literal sense that it's never been done before. And it has never been done before. Never before has the Commerce Clause been used to require that all American citizens, by virtue of their citizenship, have to enter into a commercial relationship with a private company. It's never been done before. Now, you may say, well, the federal government does so much. How can we be sure that he's right, that it's never been done before? Well, I offer two pieces of information to try to substantiate my claim that it's never been done before. One is that since I've been making this argument in last December, advocates of the bill, proponents of the bill, have failed to come up with any examples of where it's been done before. So I would think that they've had every incentive to do so, and they've come up with very creative, ingenious arguments, including my friend Jack has come up with some great arguments, but not an example of where the federal government has used the Commerce Clause power to require individual citizens enter into a commercial relationship with a private company. Never been done before. Now, the other reason why the other piece of evidence I propose to convince you that it's unprecedented in this sense is the fact that if it had ever been done before, you'd all know about it, because it would mean that all of you were subject to some kind of mandate in the course of your lifetime that was going to be enforced by means of a penalty that will be exacted by the IRS or some other government agency. And you know of no such mandate that's ever been imposed upon you. And the reason is it's never been done before. So that's where we start. We start with the proposition that the federal government is attempting to do something, Congress is attempting to do something, it's exerting a power it's never exerted before. Now, that doesn't automatically mean that it's unconstitutional, but it does mean that whatever Supreme Court precedents there are no Supreme Court precedents that cover this directly, that either say yay or nay about this directly. So it should not be a surprise that if you go back and you comb Commerce Clause cases from now back to the past, back to the founding, you're going to find no Commerce Clause cases that uphold this use of the Commerce Clause power for this purpose. And so we start with a situation in which Congress lacks authorization by the Supreme Court or vindication of their claim of power by the Supreme Court, that's where this litigation begins. Now that really, in fairness, really ought to be enough to decide this case at the lower courts. I'm not saying it will. I'm not predicting that lower court judges are not going to extend Congress's power, but that's what they're going to have to do. They're going to have to extend Congress's power beyond anywhere the Supreme Court has ever recognized Congress has a power. To me, it would seem to fall to the Supreme Court to do that, not lower courts. But we'll see what happens if lower courts become ambitious in this respect, or if all lower courts do. So that's where we start. Now, what has the Supreme Court said about the Commerce Clause? What they've said is that the Commerce Clause can be used to regulate the uses of channels of interstate commerce, to regulate the instrumentalities of interstate commerce, and most relevantly, they've said, to regulate economic activities that are intrastate that substantially affect interstate commerce. Now, that is what you recognize from the case of Lopez, United States versus Lopez, United States versus Morrison, and the case of Gonzalez versus Raich, which is the case some of you may know. I represented Angel Raich from day one of that litigation and took it to the Supreme Court and then back to the Ninth Circuit. So I argued the Raich case in the Supreme Court. I know a little bit about that case and what it says and what it didn't say. The Raich case never challenged that distinction. The Raich court case said, the majority said, not Justice Scalia's concurring opinion, but the majority opinion said that the production and distribution of a commodity, a fungible commodity like marijuana, is an economic activity, and the authority it cited for that was a 1966 Webster's Dictionary, which we all know is where we should look first to find out what the meaning of the Constitution is. But be that as it may, it never challenged the distinction between economic and non-economic activity, which was established in Lopez and Morrison, and so that case doesn't really advance the ball beyond where it has been advanced before. So what we see is that up until now, at least, the substantial effects theory by which Congress can go beyond regulating interstate commerce directly to reach intrastate activities that are not themselves interstate commerce, that theory has been only extended so far as economic activity is concerned, not to non-economic activity, and certainly not to inactivity, not doing anything. The Supreme Court is going to have to say that the substantial effects doctrine will reach decisions not to do anything. Now, I realize that what the bill does is it takes inactivity and tries to turn it into activity by calling the inactivity the decision not to do something. And so the activity is making a decision not to do anything. Well, that may carry the day. It's in the bill. But it may not carry the day. That's a decision to not do something. If that makes everything you don't decide to do into an activity, that's a very broad proposition that is going to go, I think, to the heart, as I'm going to now explain, to the heart of the relationship of the citizen to the state. Now, why do I say that? Let me move over for a bit to the necessary and proper clause, which is used to justify this bill, particularly under the necessary idea. And that relies also on a fragment of the Lopez case, which was again mentioned in the Raich case and emphasized by Justice Scalia in his concurring opinion in Raich, and that is that Congress can reach activities that they're not themselves commerce when it is necessary or essential to a broader regulatory scheme or a broader regulation of interstate commerce that would be undercut unless you can reach those activities. And we all who do this kind of work are aware of that doctrine. And that is essentially invoking the necessary and proper clause to say that Congress can reach activities that are necessary in order to regulate interstate commerce. Justice Scalia has a concurring opinion in Raich. I'm not going to go into it now. It's a little more narrow than people are reading it. I predict when Justice Scalia comes to decide this question, he's going to find it to be more narrow than other people are reading it. But that's just my view of that concurring opinion. It's not the majority opinion in the Raich case. So, and I think by the way, I think this is the strongest argument on behalf of the constitutionality of this act, and that is that it's necessary. And why is it necessary? For the reasons you've already heard. If Congress has the power over the insurance business, which the Supreme Court has already said that it does, then and Congress exercises that power by mandating, for example, a prohibition on or prohibiting exclusions for pre-existing conditions, then it then becomes necessary to force everyone into the insurance pool in order to fund and to spread the risk before you actually have a pre-existing condition. So I think this is the strongest argument on behalf of the constitutionality bill. If the bill is upheld, I predict it will be upheld on this ground, that it's not only going to pass a rational basis scrutiny, that's necessary, which is all that the court has held, although that's what the Raich case says, but Justice Kennedy's concurring opinion in the Comstock case suggests he has a somewhat higher standard of scrutiny. But I think it might even withstand, the highest scrutiny you want to bring to bear on it. It is necessary. I mean, it's not unreasonable at all to think you have to do this thing. But that's only half of the necessary and proper clause. There's also the issue of this measure's propriety. And that's where I think you need to stop and think about things. Because, in fact, even though it is unprecedented to use the Commerce Clause to mandate that someone enter into a commercial agreement, it is not unprecedented that the federal government might mandate you to do something. That's not unprecedented. There are examples of that. They're very few, but we can think of them. What are they? They are the mandate that you sit on a jury when called for jury duty, the mandate that you register for selective service and then serve in the military if called, the mandate that you pay your taxes. There isn't even a mandate in this country to vote. As important as that right might be, we don't mandate it. Other countries, less free than ours, do mandate that, but we don't. So there are mandates. Well, what do these mandates have in common? What these mandates have in common is they are something that is intrinsically bound up in what it means to be a citizen. And they involve the fundamental duties that citizens owe their government in return for what government provides them, which is usually, first and foremost, protection. So what the court is going to have to say, and these duties are very limited in our history. What the court is going to have to say to uphold this mandate is that the duty that Congress creates that you enter into a contract with a private company is of the same nature and of the same order as the duty that you owe the state by virtue of the protection the state gives you. It's like the duty to register for the draft. It's like the duty to pay your taxes. It's just like that duty. Now, some of you may find that just fine. The people that are not bothered by this have no problem with that proposition. They think you have a duty to do whatever Congress commands you to do, as long as Congress has a rational basis for doing so. I understand that position. I don't agree with it, but I understand it. But others of you, I think, if you stop and think about it, might be a little nervous about recognizing a power in Congress to mandate that you do something that Congress thinks is in your best interest and its best interest that you should do under a rational basis scrutiny. Anyway, is there any law that would point the way to an answer? I mean, one thing to say, look, it's never been done before, it's unprecedented, that means it could go either way. But is there any reason, any principle that's in the Constitution and in decisions of the court that would argue against the unconstitutionality of a mandate of this kind, of this nature? And I think there is. For one thing, there are anti-mandate provisions throughout the Constitution. The 13th Amendment is an anti-mandate provision. It prohibits the mandating of labor. The Third Amendment is an anti-mandating provision. It prohibits the quartering of soldiers in houses in time of peace. That's another The Fifth Amendment's Taking Clause is an anti-mandate provision, which prohibits the taking of private property for private use, period. There are a number of these anti-mandating provisions that evoke an underlying principle. Now, what about constitutional cases? Well, you do have a line of cases, and this is the last thing I'm going to talk about before I close. You do have a line of cases that talk about mandating, only the word is used, the word that's used in these cases is commandeering, not mandating. And what are those cases? These are the 10th Amendment cases that say that the Congress, notwithstanding any good purposes it may have, cannot commandeer state legislatures, New York versus the United States. And the Congress, no matter what good purposes it might be trying to achieve, cannot commandeer state executive branch officials. That's United States versus Prince. So these are anti-commandeering cases that reflect the same kind of anti-commandeering principle that I mentioned in the clauses I just talked about. Now, what did the court say in the Prince case about the necessary and proper clause? What Justice Scalia said in that case, the same Justice Scalia whose concurring opinion in Raich people are looking at, What Justice Scalia said in the Prince case about the necessary and proper clause is it may be necessary, but it's not proper. It's not proper to commandeer state executive branch officials. He also referred to the necessary and proper clause as his last great hope of those who advocate ultra-virus congressional power. So it's not like he's a huge fan of the necessary and proper clause in this context. But the issue here is it improper to commandeer individuals in the same way and for the same reason it's improper to commandeer the legislatures and the state executive branch officials? Now, I'm not claiming the court has ever held that. Believe me, I'm not saying that. I've given you what it has talked about. But then what does it rely on when it evokes that principle? It relies on the 10th Amendment. And what does the 10th Amendment say? The 10th Amendment says that the powers not delegated to the United States by this Constitution are reserved to the states respectively or to the people. It doesn't stop with the states. It goes on to the people, the same 10th Amendment. So the question is this an unconstitutional commandeering of the people? And I submit that it is. It's unconstitutional, and it's a commandeering, just as it's the commandeering of state legislatures and the commandeering of state executive branch officials are unconstitutional commandeering because of the sovereignty that resides in the people, first and foremost, before we ever get to the states. Now you may say, well, that's a novel argument. And I agree. But why is it a novel argument? Because, and on this I'll close, this has never been done before. That's where I started. And something that's never been done before is going to require a novel argument on both sides. All the arguments you're going to hear from now on by anyone are going to be novel, including this one, and including the one that Jack's about to present to you, in which he's going to tell you, nothing big to see here, move along, no big deal, routine garden variety kind of regulation. My friend Jack.
Randy, thank you. I think we can all agree that that was as forceful, eloquent, and fairly stated an argument in support of the proposition that the minimum coverage provision, as NARA calls it, and the individual mandate provision, as Randy calls it, is unconstitutional. And I can't help but point out the irony of what it is you're witnessing, because you've just heard an eminent libertarian conservative make the case that the only way in which Congress and the American public could attain universal health care coverage constitutionally is through a single-payer government-mandated system that is paid for by taxes. I think that is the implication of what you were saying, Randy. And now we're going to have Jack Balkin, noted liberal, explain why this is not true and actually why a system that accommodates, that is primarily a private business insurance system can be turned into a universal coverage system. Okay, Jack.
Thank you. So I thought it might be helpful if I just followed the structure of Randy's argument so that you can see, we can do the point-counterpoint yourselves. Randy started with the Commerce Clause, or basically his argument was primarily about the Commerce Clause, and he made two important points. And the first point was that under existing precedents, the regulation of individual activity is not actually a regulation of individual economic activity at all. It's a regulation of something that's not economic and is not activity. And the second point he made was a point about necessary and proper. So first let me start with that. As Neera points out, and which I'll expand on, the logic of the health care bill is this. If you want to have must-issue rules, that insurance companies must issue policies to people with pre-existing conditions and can't impose lifetime caps and can't place other restrictions on gaining health insurance, then you're going to have to expand the national insurance risk pool. You're going to have to bring a lot of new people into the system. Otherwise, if you don't have something like an individual mandate, which you either could pay for through a single-payer system, or you could pay through an individual mandate. If you don't do that, what you're going to get is an exacerbation of something that already occurs in the insurance markets. Currently, if you're young and healthy, you engage in a kind of time-shifting policy of investment. That is, what you do is you gamble while you're young and relatively healthy that you won't get sick in a serious way. And you currently gamble, and if you guess wrong and you get a serious illness and you have a pre-existing condition, you won't be able to purchase health insurance. So you engage in a kind of time shifting, kind of bond speculation, kind of a Salomon Brothers 1980s bond speculation is basically what you're doing with your health and your life. What the new bill does basically is allow you to speculate more freely if you didn't have the individual mandate, because now the government will guarantee that you can get health insurance. All you have to do is just wait until you get sick. You march up to an insurance company and say, "Hi, I'd like some health insurance, please. And by the way, I have the following conditions." And they have to give you insurance. What this will do, if you didn't have an individual mandate, would be to explode the system, because you would have the people who you would have what you basically have is an adverse selection problem, as they say in economics. And people are completely rational. The Hill Bill assumes that people are rational, and it assumes people will make rational economic decisions, and it assumes that without an individual mandate, people will wait until they get seriously ill. So they will essentially be playing with other people's money. They will be basically bond speculators. I was reading A Liar's Poker the other day. That's why this is on my mind, about Salomon Brothers. But in a sense, it treats people basically as rational actors who engage in rational economic decisions. What the individual mandate does is to prevent people from engaging in that kind of time-shifting, rational, speculative behavior. It basically says that what we're not going to allow you to do is wait until you get sick to get health insurance, because you're going to try and buy health insurance as soon as you get sick. We know you'll do it. You're a rational agent. We're going to make you buy the health insurance now. We're going to make you invest earlier about a purchase you would make later. So that's the time-shifting point. The other point is, in this system we currently have without an individual mandate, it's not the case that when people get sick, they just do nothing. They borrow from their families and friends. They go to the drugstore and buy over-the-counter medicines. And they engage in something that's called uncompensated medical activity. That is, they go to an emergency room and they plop themselves down in front of a hospital and say, "Take care of me." And under federal statute and state statute, hospitals that receive certain kinds of funds or certain kinds of hospitals have to do it. And people are rational and they know that they have to do it, so they go ahead and they do it. And the CBO estimates in 2008 is that this uncompensated care cost $48 billion. Let me repeat that. Actually, it's $43 billion. I only cheat out of $5 billion. Billion here, billion there, starts add up to money. The key point to understand is that when you say there's no economic decision-making going on here, and there's no economic activity going on here, that's not true. There's $43 billion worth of economic activity going on here. There's $43 billion of cost shifting, time shifting, and economic speculation going on in the activities of ordinary Americans, who the health bill assumes are not idiots, but are completely rational agents who understand that what's in their best interest is to make decisions that will save them money in the long run. And what the health bill does, essentially, is to say, we understand that you're in this economic predicament, and we understand that given this predicament, you will make these following economically rational decisions. And given the fact that you will do so, we are regulating the markets to make sure that the decisions you make it possible for us to offer virtually universal coverage for people. So the first point Randy made is that this is a regulation of non-activity and it's not a regulation of economic activity. On this, I beg to differ. So I think, in fact, the courts will probably see it this way, but of course, who knows? But if you want the question of why it's economic activity, that's the reason why. The second point Randy made, and I think that he is exactly right, that courts are much more likely to move directly to this sort of necessary and proper argument, is this. Given the economics of healthcare and given the economics of health insurance, you can't have an effective regulation of healthcare markets and an effective regulation of health insurance if you don't bring in people who are uninsured, either through government subsidy, which the bill does, or through an individual mandate, which the bill also does. The system just won't work. That is to say, put in terms of constitutional doctrine, in order to make its regulation of national health insurance markets effective, it is necessary for Congress to include currently uninsured persons who would join the system later once they got sick. And that's a standard, necessary, and proper argument. And Randy has rehearsed it. I don't have to elaborate on it. I think he did it very well. And under that, it's within necessary and proper clause. But Randy's point, and I thought that was also very important that he put it this way, is ask this question. It may be necessary to make effective health insurance regulation occur, but is it proper? And he then came, I think, to the nub of the issue. And let me restate it in a slightly different way. Randy said, look, where does the government require you to do things? It requires you to purchase insurance for your car if you're a driver, right? But not everybody drives. It requires you to serve on a jury. The Militia Act of 1792 required you to contract with a private business to purchase ammunition and a gun, right? But what's interesting about the Militia Act was it was passed in a time. No, actually, you should take this very seriously because it teaches an important lesson about the Constitution. The Second Amendment had multiple meanings, and one of its meanings was a civic republican meaning. The idea was that you were supposed to sacrifice your body for the state in order to preserve the republic. It was both a duty and a right. It was a right to bear arms, but also a duty to act in such a way as to preserve the liberty of others. That's what we mean by republican government, res publica, a public thing. And that's why the 1792 Militia Act had that obligation to purchase. Not because it was the right to bear arms, it was because it was a duty to preserve the republic. It was about a conception of rights that is almost foreign to us today. So Randy correctly raised the question, why this mandate and not any other mandate? When Barack Obama finally signs the bill, he finally says something I wish he had said at the very beginning, but he didn't. He said, today we finally established that every American has a right to health insurance. Every American has a right to health care. That part of what it means to be a citizen is to have a right to this kind of protection. And I breathed a huge sigh of relief. I said, why in the world did the man not say that at the very beginning of this debate? That's what this debate was all about. To make a point that Nero said before, that's what we will remember this debate to have been about. That's what it was about. What Congress essentially did in this bill was to say that everyone has a duty to purchase insurance so that it's possible that all of us can have effective health care. That is to say, it really was a kind of civic republican idea. The idea is that this isn't just about go out and buy any product. It's go out and buy a product which, when you purchase it, will make it possible for everyone else to be taken care of in the healthcare system. Very few kinds of products fit that definition, have this kind of time-shifting problem, bond speculation problem. In fact, I couldn't name more than one or two. Maybe funeral insurance would be the only other one I could think of. Everyone's going to die. They're going to need a funeral at some point. So you can imagine speculation on the funeral insurance market. But they're very rare. And only one of them, which is this health care, is this one that now we understand, and Congress, the elected branches of government, have understood is a basic right of citizens. And that's why it's both necessary and it's proper. The last point I want to make has to do with a point that Randy raised, which I also agree with. He said, ask yourself, what kinds of mandates has the government imposed on us where we all have to do it? There are really only two things you really have to do in life, right? One is to die and the other is to pay taxes. And the answer to Randy's question is, yes, government makes you pay taxes, whether you want to or not. And that's the last thing I want to tell you. The individual mandate actually isn't a mandate, it's a tax. It's an amendment to the Internal Revenue Code. It involves collection by the IRS. It says in the bill that the Internal Revenue Code will collect the tax, that the taxpayer has to list information on the tax return. It is a tax. The question is this tax within the power of Congress to tax and provide for the general welfare? And the answer is the test, which was offered during the New Deal, so therefore this is old law, is could Congress reasonably conclude that its taxing and spending policies promote the general welfare? My view is it not only could reasonably conclude this, but it's reasonable to conclude that, in fact, this promotes the general welfare. This is a slam dunk argument as far as I'm concerned. Why, in fact, did Barack Obama not go around and tell everybody that this was a tax? Why does it just appear as an amendment to the tax code? You know the reason and I know the reason. He has this interview with Greg Stephanopoulos in November, in which Greg Stephanopoulos says to him, this is a tax. George Stephanopoulos says to him, this is a tax, Mr. President. And Barack Obama says, oh, it's not a tax. and Stephanopoulos says, no, it's a tax. I read the bill. And Obama says, it's not a tax. I watched this thing, and I said, Barack Obama, you are going to rue the day you said that. And he is now ruining the day he said that, because basically he has not been honest with the American people about the nature of this bill. This bill is a tax. Because it's a tax, it's completely constitutional. It's constitutional under General Welfare Clause, under the same provisions that upheld Social Security. Completely constitutional. Well, is there any argument we could make that the tax is an unconstitutional tax? I think there are two of them. One possibility is that it could be the tax, the secret penalty in disguise. It's a criminal penalty. But it's not that, and the reason we know that is the tax itself says that you can't be criminally punished for paying, not for refusing to pay it. Congress stripped any criminal prosecution from the penalty. The other thing Congress did is not only can you not be prosecuted for failing to pay it, the IRS can't even bring a tax lien, can't even impose a tax lien on your refund. The only thing that the IRS can do is fail to give you as much refund as you asked for. That's the only way they can effectively collect it. So it can't be a criminal penalty of that kind in disguise. The other possibility is that it's a direct tax or a capitation tax. It's not a capitation tax. A capitation tax is a head tax. That is, no matter what you do, just for standing there, we're going to tax you a certain amount. No head tax or capitation tax is a tax of the sort that you can get out of it by doing something. In this case, if you just buy insurance, you don't have to pay the tax, so it's not a capitation tax. The last possibility is it's direct tax. This is Article 1, Section 2 and Article 1, Section 9. The direct tax clauses are a compromise with slavery. Ladies and gentlemen, they were put in the Constitution as a necessary feature of the compromise with the South. The South was worried that the North would gang up on them and impose taxes on land or taxes on slaves in various forms. And what the compromise that was reached was to tie representation to direct taxes and to say that, and if you look at Article 1, Section 2, it says that representatives and direct taxes shall be, in turn, with the famous 3/5 clause. So the direct taxes are based on the 3/5 compromise as well. By the way, the 14th Amendment doesn't change this. It changes with respect to representatives. So technically, the 3/5 clause is still with us. If there are any people who follow under the 3/5 clause, direct taxes, you only count 3/5 of them. When one of the first Supreme Court decisions considers this, and Hilton versus United States, it's a tax on carriages. I should tell you, the tax on carriages in those days was like a tax on two-seat sports cars. It's what you bought when you had a midlife crisis. If you really want to show off your wealth, you would buy a carriage. So Congress imposed a tax on carriages, and the question is it a direct tax? It's 1796, one of the first Supreme Court's first decisions, they say, oh, come on now. This is not a direct tax. Direct taxes are about slavery and taxes on land and head taxes. And since it's tied to slavery, we will interpret any tax as not being a direct tax unless it's absolutely necessary. So when in doubt, it's not a direct tax. And that rule, by the way, has been the rule since to the present. There's one exception. It was a case called Pollock, you may have heard of. 1894 held the income tax unconstitutional. It was overturned by the 16th Amendment. Essentially, the tax argument is the strongest argument for upholding it because it is a requirement of every citizen and non-citizen to pay taxes, and it is tied to a fundamental right of citizens, the right to secure health care.
Thanks. And I think we'll all agree again that this was a extraordinarily eloquent and learned presentation of the case for the constitutionality of the mandate and of the legislation. We're now going to have a period of people on the panel asking other people on the panel some questions. I'd just like to ask everyone to try to be real concise in sketching out the way you would answer these questions, because we also want to leave some room for people in the audience to ask questions. And then we're hoping to have 15 minutes or at least 10 minutes for people just to network in the room, come up and talk to the panelists and so forth. I want to ask one question of Jack and one question of Randy, which I'll do serially. In my involvement in this great debate, it has seemed to me that each side has a really good zinger that it puts to the other side, and that neither side has been terribly good at responding to these two zingers. So I'm going to try to do that. Jack, if Congress can do this, if Congress can make you buy a product because that would have a beneficial effect on some problem involving interstate commerce that it might appropriately designate, there's no limit, is there? What is the limit in this theory about what Congress's power might be? Can it make everybody buy health food in order to improve their health? And can it make people buy General Motors cars in order to increase employment in America? Is there any limit? And what is it in your theory?
There are two limits. One limit, well, there actually are three limits. The first limit is you have to show that it's necessary to make a regulation, a national regulation effective, which I don't think you do in it. Oh, I'm sorry. First, you have to show that it actually is necessary to make a regulation effective. If you can't do that, and you can in this case, then it's not constitutional. Secondly, it has to be proper. I mean, I think Randy's got it. It's got to be necessary and proper. It can't violate any existing fundamental right. It can't violate any structural guarantee in the Constitution. The third guarantee is that it has to get past both houses of Congress and be signed by the President, which in fact is, after the New Deal, the basic way in which we protect our citizens from an overweening legislature and president who try to invade our economic liberties. The basic New Deal settlement is that where economic liberty is at stake, not other kinds of liberty, but where economic liberty is at stake, we rely on the political process largely to prevent unwise legislation. And that if legislation turns out to be unwise in the long run, the political branches will take care of it. So if we were to, so what we have not discussed here is a situation in which the health care bill impinges upon rights, for example, of bodily integrity or health care rights that we talked about before. In that case, it would be a very different story.
Okay, I'm going to give Randy a chance to comment on the adequacy of Jack's answer to the conservative zinger on this point. And I'd also just like to add, Randy, if you don't mind, I'd like you to very briefly respond to what I think is the liberal zinger, and that is you've heard all of these enormous problems that exist in our health care and our health insurance markets, and you've also heard that the mandate is essential, really, to be able to address these problems. Is it really true that the Constitution forbids the American public and their representatives from fixing those problems?
Well, I do want to talk a little bit about the tax thing, because that's something that may be new to some of you, or maybe not. Let me talk about the zinger first. Part of the problem that gives rise to this pre-existing conditions issue, which is the one that has the most political salience, has to do with people getting their health insurance from their employers, which is a historical artifact that dates back to World War II, and it had to do with wage and price controls and the need to get around that, and so employer-provided insurance was not counted as under wage and price controls, so people start becoming accustomed to getting their insurance through their employers, and then what happens when you change your job? You have to get new insurance. So most of the people who are having problems with pre-existing conditions are people who have changed jobs, or they've gone out of the employment market and back into the employment market. And so this whole notion that we don't have the same kind of pre-existing conditions problem or the same kind of insurability problem with other forms of insurance, with life insurance, which is not tied to employment. You get life insurance and then you keep your life insurance. You get auto insurance, and then you keep your auto insurance unless you get into an accident or you become rated for some reason. But it's only with this kind of insurance that got historically tied to employment that you create this problem in the market. And this was a government-created problem. So that's not much of a zinger response. I realize it's kind of wonkish. And I'm not an expert in this field. I'm just evaluating this as a citizen, not as a health policy expert. But to me, that's part of the problem. And going back to the initial zinger I overlooked so that I could make my comments about the single-payer plan, it seems to me that if Medicare is constitutional, Medicare for everyone is constitutional. And the question is, whether Medicare is constitutional is settled. So none of the arguments that I've made today or elsewhere are based on the original meaning of the Constitution. Perish the thought. If we talked about the original meaning of the Constitution, we wouldn't be having this conversation, right? This would just be a dead bang winner, but for its unconstitutionality. But we're not talking about that. I'm not talking about that. You haven't heard me say anything about that, and so we're not talking about that. We're talking about existing law, existing doctrine, and the theory that underlies it. And if Medicare is constitutional, under a tax and spend theory, and the theory of tax and spend that has prevailed throughout history has not been the Madisonian view that the taxation power has to be tied to an enumerated power, that the only power to tax is a tax that is to facilitate an enumerated power. But the Hamiltonian view prevailed, which is that you can tax for the public interest. Under that view, and you can see, so this debate goes all the way back to the beginning. If that view is right, and Medicare for some is right, Medicare for everyone's right, except I think the only exception I would make to that is that there would have to be, for other reasons, there would have to be some kind of opt-out, like there is in England, but there isn't in Canada, let's say, so that you could provide your own health for your own health care over and above. So unfortunately, that leads to a two-tier system, which people are bothered by. That might be constitutionally required, but not that you couldn't have a single-payer plan. As long as there was not an opt-out. It's the same kind of opt-out you have for Social Security. You can provide for your own retirement on top of Social Security. And with Medicare, you can provide for your own medical care on top of Medicare. So that's the kind of opt-out that would be consistent with the single-payer plan that has been upheld so far. So yes. So there's your answer. If you want to do something constitutionally, as recognized by the courts, you have to do that now. Now, Jack's argument is that that's what they did. They did something like that. That's why he's linking this to the tax power as opposed to the commerce power. And then the question is that argument going to work? I just want to say something very brief. I can only say something. I have to say something either very briefly about that or something very long. So I'm going to just keep it
brief.
Brief, right?
We all know that it's more complicated.
And the problem here is really with some nuances of existing Supreme Court rulings on this question and how you interpret those cases. This is not a matter of first principles. This is a matter of Supreme Court doctrine that started before the New Deal and started really getting settled around the 1950s. And some people read this. Jack, by the way, I do commend to you Jack's amicus brief in the Virginia case, which was filed this week. I've read it. It's very good. It's the most cogent argument on behalf of this tax theory that I've seen, and I highly commend it to you. I wouldn't. If you want to read my amicus brief that I filed also, you might want to read that too. But
it's the most cogent one you've ever read.
That's right. So, no, it's not. But it's anyway. So, but Jack lays out the whole tax argument there very, very well. So, just two ways of reading these cases, and then I'll stop with the tax argument. The one is the way it basically says like. The way I read these cases is if Congress calls something a tax, before the New Deal, the court would look and see whether it was really a tax or whether it was really a way of circumventing the enumerated powers scheme. Now, in fact, the law that says that has never been overruled by the Supreme Court. The Bailey case, which says that Congress can't circumvent the enumerated powers by an ostensible exercise of its tax power, has never been overruled. What has changed since then is the Supreme Court's interpretation of the enumerated powers. One reason why that argument became sort of irrelevant is that when the Supreme Court greatly expanded the reading of the Commerce Clause, it wasn't necessary for Congress to engage in circumvention anymore. And if Jack is right, circumvention's back. If Jack is right that this was an exercise of the tax power, they're circumventing again. So now the question is, will the court want to recur back to Bailey now that circumvention's happening and see if they want to renew the anti-circumvention principle? Okay, that's one thing. But there's the real problem. What the cases really say is when Congress calls something a tax, we're not going to look behind its label and examine its motives to see if it might have a regulatory purpose. As long as it has a revenue function, we're going to uphold it as a tax. Every single case that Jack cites and that anybody cites on behalf of this principle is where Congress labeled something a tax. The problem is, in this case, Congress did not label it a tax. The House might have wanted to label it a tax, but the Senate did not label it a tax. They labeled it a penalty. It's a penalty to enforce a requirement. Tax is not used. Now, it's true, it's included in the Internal Revenue Code, and it's enforced by the IRS. But that means that there's a proposition involved here, and that is that any penalty that Congress wants to enact is within its power as long as it has the IRS do the enforcing. Believe me, I don't think that's a principle that's going to sell. That they have a plenary power to impose any financial fine they want to as long as the IRS is the one that's doing the collection. That makes it a constitutional tax? No. Right. Not only did they not call it a tax, but there is a section of the bill which talks about revenue offsets in which they scrupulously count up all the revenue that the bill is going to receive. And in order for scoring, CBO scoring, this was very important. Did they include the revenue to be collected by the individual mandate as part of those sections? No. They didn't count that revenue. Now remember, one of the qualities a tax has to have is it has to have a revenue-raising purpose. Not only...
I'm not sure that's true, actually, because the Joint Tax Committee said it would save $4 billion.
The Joint Tax Committee was a report issued, as you noted in your brief, or just shortly before the President signed the bill. It was not part of the bill itself. The bill itself, which lists the offsets, does not list this as an offset. And so it doesn't anticipate... And the 8 bases, the 8 findings as to why the mandate was necessitated that is listed in the bill, none of them includes revenue raising as one of the purposes. So all I'm saying is this is all doctrinal stuff. It's not first principles. It's not any of those things. We're just arguing about what the cases have said. And what I think the cases have said is this. If Congress calls something a tax, the court's not going to look behind it to see what its true purpose is. There is no case that's ever been decided that says that if Congress calls something a regulation of commerce, which is what Congress did call this, the court, if they find that's an inadequate assertion of the Commerce Clause power, will reconstruct that exercise of power as though it were a tax and evaluate whether Congress could have passed it as a tax.
McCulloch.
There's no provision.
All right.
So anyway, let me just go back to kind of a bottom line as to what's real in the courts. I mean, I think this, by the way, all this is real in the courts. Here's the only takeaway I want you to take away from this. If there are 5 votes of people of justices who want to uphold this bill, they have more than ample argumentation being provided to them by the government, by Jack Balkin, by lots of people as to why they can justify this. You've heard those arguments today very eloquently, as you've heard. If there are 5 votes that are suspicious and question whether they want to uphold this, they will have to reverse no Supreme Court precedent to do so, and you've heard the argument that will be made against the constitutionality of this measure. So then the question is, what do the justices want to do? You know why? Because this has never been done before. So it's going to be up to them to decide what to do.
Thank you both very much.